The defense is moving for a mistrial. During the testimony of Dylan Kramer, he was shown two Snapchat videos that were admitted into evidence over the objection of the defense. The objections of the defense were that they were cumulative and that they were inflammatory. Mr. Wheeler adopted the same argument that he made during the state admission of Exhibit 5. These were two Snapchat videos that were taken by Matthew Walker inside of the classroom of 1214. During the testimony of Mr. Kramer, he indicated and provided eyewitness testimony as to what he had seen and what he had heard, indicating a description of the firearm that he believed that he saw, as well as the individuals that he witnessed being murdered. When the Snapchat videos were published to the jury at the highest volume possible, and it was also displayed to the gallery.
Let's not say things like that unless you don't approve that.
I do believe that the state admitted. He said he had it at the highest volume possible, and then he had to reduce it. The video was also displayed to the gallery. It was during that time that one member of the victim's family or friend made an audible response saying, "Turn it off, turn it off." It was at that time that the court turned on the white noise. The Broward Sheriff's Office followed the instructions that the court had previously given them, which was that any individual who is disruptive or has an emotional outcry should be removed by the Broward Sheriff's Office. Judge, it is necessary to declare a mistrial in this case because the jury was present during all of this. It would bring unfair prejudice to Mr. Cruz, impairs fair trial rights. It could inflame the jury, garner additional sympathy and anger towards the client. A denial of this motion would violate Mr. Cruz's right to due process guaranteed by the 15th and 14th Amendment of the United States Constitution, as well as Article 1, Section 9 of the Florida Constitution, and 6th and 14th Amendments of the United States Constitution, Article 1, Section 16 and 22 of the Florida Constitution, as well as the 9th and 14th Amendments of the United States Constitution, equal protection and basic rights guaranteed by the 14th Amendment of the United States Constitution. Based on the foregoing reasons, the defense moves for a mistrial as the prejudice to Mr. Cruz by what happened in this courtroom in front of the jury would render this court to provide Mr. Cruz with the ability to have a fair and impartial trial. This is upon consultation with our client, and he is in agreement.
Okay, first of all, my desk is elevated, and I could not see who was speaking because the person is in at least the 6th or 7th row, which I would say is at least 150 feet from the bench. That's number one. Number two, I couldn't hear what the person said. In the abundance of caution, I asked the white noise be put on. But somebody shouting one thing when you don't see them or you can't hear exactly what they're saying is not even close to grounds for a mistrial. The jurors, I don't even think any of them looked. As far as the volume being on the loudest volume possible, that's not grounds for a mistrial. I asked the state next time, turn it down a little bit, but so that people can see it, but your motion's denied.
I understand the court's ruling, but as an officer of the court, I can make a representation that I heard the individual in the gallery of this courtroom say twice, "Turn it off, turn it off."
Do you want to say anything else, State? I advised the lawyers what the witness said because the sheriff's office told me.
Your Honor.
And that's the only reason that I knew. The defense did not tell me what the witness said until just now, as an officer of the court or not.
Your Honor, the state agrees with the court's ruling, and the volume was very loud. It was extremely loud, and I think that the witness, or not the witness, turn it off, turn it off. The volume was so loud as to turn the volume down, Your Honor. That's what it could be attributed to. And we agree with the court's ruling. The motion for mistrial should be denied.
All right, State, do you have another witness to call?
Yeah.
Okay, go ahead.
Jury's not here.
Oh, can you name it, please? Thank you for reminding me.